Lawyers are stupid, don't pay them. Hi everyone, good to see you tonight. So I am not an employment attorney, but I am an attorney that knows some stuff about employment. So I'm gonna try to come through. So I'm kind of here to give you the background on the law, some information that's just trying to break down exactly what's happening, and then I'm gonna, try to give you some suggestions at the end. We're hearing from a lot of the communities, they go to events like this, and they are hearing a lot about the law, and then at the end it's like, okay, but what do I do about that? Mm-hmm. So we try to add in something at the end that gives you a little bit of info on what you want to do. And Pamela, you want to just say a little bit about so I'm going to be like the boring part.
Well, we see. We might be co-boring parts. But I am speaking, I guess, experientially from the standpoint of what the National Writers Union did in terms of trying to help the bill be more representative of the needs of writers. Somewhat successful, somewhat not successful. So I'm going to talk about what we, our part in it leading up to the signing.
So the first thing before we move on to the next slide, I do want everyone to read this. This is not legal advice. I do have to say that, being a lawyer. Don't get me disbarred. This is just general information. If you need an attorney, you can contact our lawyer referral service. It is actually a sliding scale. If you qualify for pro bono, all your consultations with an attorney are free. If you don't qualify for pro bono, we have a lot of different other options that are lower hourly rates and then full price attorneys as well, but we can try to get you hooked up with an attorney. We also do clinics all across the state. All of our clinics up in the Northern California offices are attended by phone as well, so you would get a live stream and could talk to an attorney for 20 minutes by phone. And all of our clinics are very, very low rate, like about $15, $20, and it's kind of pay what you can, and you would get a consultation completely free with that $15 with an attorney. So if you have specific questions and concerns, clinics and the lawyer referral service are a good way to go. Also, mediation services are very, very helpful, and it's the best way to save yourself money because court costs a lot of money. Lawyers are stupid, don't pay them. So a little bit of the overview of independent contractors. Everybody knows this because this is what you're here for, but just basic thoughts. There's some negatives about being an independent contractor, right? There's no employee protections. Employee protections include some things you forget that you don't get, like discrimination protections. The Civil Rights Act and the Fair Employment and Housing Act. Civil Rights is federal, Fair Employment and Housing Act is California. They don't apply to you if you're an independent contractor. Basically, someone can discriminate against you if you're an independent contractor. Same thing, the ADA, the Americans with Disabilities Act, does not apply to you. So, it may not come up for you, which is great. If it does come up, that can be more of a problem when you're an independent contractor than if you're an employee. Also, there are no federal or state, you guys probably know this really well, there are no federal or state taxes withheld from your pay. You gotta do it yourself, right? You gotta kind of estimate that and do the whole thing on your own. And then you have to pay your taxes directly to the IRS, so on and so forth. But then there's a lot of positives. So you have, you can control your own hours, you can work without direct supervision, you control your own intellectual property, which is a really big thing for artists. And then you can do your 1099 reporting, write off your business expenses and such. So, there's positives and negatives to being an independent contractor, and I just wanted to go over them because these are a lot of the things that might change for you if you have to be employed, or change for you if you're going to start employing people as opposed to hiring them as ICs. I wanted to give a little bit of a basis for what was happening before AB5. We're all freaking out, there's this huge change, but what was it before? What are we changing from? So the first thing is that there was always a test to determine independent contractors versus employees. It's always existed. I mean, not since the dawn of time, but since the Copyright Act, since the 40s, there have been pretty strong tests to determine whether you're an independent contractor or you're an employee. The most common one is the IRS test. It's got 3 categories. Biggest one, and you're going to hear this a lot tonight, the right to control. Who controls how to do the work? Do you get to go home and do it and just bring in the end of the project? Or do you have to do it based on how someone is telling you how to do it? You have to put, you have to type this here, you have to, come into this office at this time. The second part of the test is financial autonomy. So what business aspects of the job are controlled by the person paying? So that means like who provides the tools, who provides the resources, right? Or do you get reimbursed for those kinds of things? And then the last prong of this 3-prong test that the IRS uses is, what's the relationship? Is it ongoing? Do you get benefits? You know, is there some kind of insurance? Will the relationship continue, you and this person hiring you, or you and this person you're hiring? Or is it kind of a one-time project-based thing? So that's the IRS test. It's got 3 prongs. The Federal Department of Labor's test. This is the wage and hour division. They have 6 factors. They sound a lot like the other 3 factors, except just expanded into more complicated factors. Lots of stuff about control, lots of questions about permanency, who has the financial control. So all those things, they already exist. And it's worth thinking about for yourself, you know, do I pass the other tests? Even if I pass the AB5 test, which is new, which we're gonna get to, like, am I in control enough of my finances as an independent contractor? And am I in control enough of my work that I'm producing as an independent contractor that I really should be an independent contractor? Because if you're not, if someone's giving you a schedule and saying you gotta come in and saying you have to work these hours, the problems that happen with the Dynamics case, which is actually said Dynamics, just found that out. The problems that happened with that case, that was because those workers were going in 40 hours a week, and they really should have been covered. So if you are in that kind of situation, or if you are hiring someone that ends up being in that kind of situation, you want to start to think about that, because AB5 doesn't change that law. The federal laws, including the IRS and the Department of Labor, and Borello I'll talk about in a second, but the 2 federal laws, think of them as a floor. California's laws can sit on top of that floor, but you can never go lower than that floor. So even if you pass the California law, you still have to get through the tests of the federal law. It's just that we weren't thinking about those before. So now it's maybe worth considering them. The last thing that still will exist, even if you pass the AB5 tests, is Borello. Borello is a case that we're going to talk a decent amount about tonight. I only have a lot to get through, so I'll probably try to talk a little faster. But it has 11 flexible factors. They already exist as law, and if you pass the AB5 test, it just kicks you back to Borello. It doesn't mean you're suddenly an independent contractor, no problem. So we can talk about that as well. So these are 2 federal and 1 California, the state law. Okay, what happened with Dynamics? Which I really want to say Dynamics, but Dynamics. They were really dynamic in messing up their workers. So this is a California Supreme Court case. Happened in fall of 2018. The biggest thing is that California law already presumed that somebody was an employee. And they set up this bar that you had to get over. You have to overcome the presumption, is what we say in the law, to prove you're an independent contractor. Bet you didn't know that. Bet you didn't know you were already considered an employee until you prove you're an independent contractor. So Dynamics tried to investigate that presumption, right? So the company comes in, it was about delivery drivers in Central Valley, and the company came in and said, no, these guys are independent contractors. They're trying to overcome that presumption that they were already employees. And the court told the company to basically get out, and said that they really wanted to protect these people more, because essentially the Dynamics company had employed all these people, and then they turned around and they made them all independent contractors. So that's like a big problem. Like, don't anybody do that. So this is a case, I like to say, where a bad case makes bad law, right? It's like a really tough case that the judges felt really, really concerned about the workers, because they should, but then they made this decision which encompassed a lot more than they expected it to. So the goal was to allow workers to provide for themselves and their families with dignity, and also to ensure that businesses who are actually employing workers were not undercut by unfair competition with competitor businesses who are just employing independent contractors. So they had like good intentions. So let's talk about the Dynamics test. It's 3 prongs. Prongs sound very similar to what you are used to, well, what you are now used to, that already existed in the law before, right? Federal and state. Are you free from control and direction of the hiring party? Well, that's one we're used to, right? Like the control, independent contractors want to control their work. That's why they're independent contractors for the most part. And they get to, right? So that's the first prong. I'm going to skip to prong C because prong B is the real kicker. So we'll just put that in the middle there. From C is, are they customarily engaged in this independently established trade? So if you're an actor that goes and performs at different theaters, are you regularly an actor? Or are you only an actor for this one business? Are you writing for most of your work, or did you just write for this one contract? They want to know that you are already doing that kind of work regularly in your worker life, right? And then the B prong is the one that is so tough. And the other part that's so tough is, unlike the previous tests that we talked about, IRS test, the kind of more Department of Labor tests that are federal, and then the Borrello test, which is California, those are all squishy. Those are all like, if you kind of do this one okay, and you kind of do this one okay, you're going to be all right. It's what we call a totality of the circumstances test. So you're just kind of there. The judge would look at it and say, okay, do you seem like an independent contractor? Gut check, like trying to tick all the boxes, okay. Dynamics changes that, and it says you have to pass all 3 prongs of the test no matter what. And the B prong is the hardest prong, and that is you have to perform work outside of the usual contracting party's business. So you can be a plumber and come into the theater, because the theater doesn't offer plumbing usually, I mean, other than for its customers to use the restroom, right? But it doesn't offer that service. But if you're an actor that comes into a theater, if you're a writer that comes onto a magazine and writes, an article, that's like within the course of their regular business. And this is the thing that makes it really tough to pass for a lot of people. And so that is really essentially, that B prong is what essentially makes everybody employees. And because it's really, often someone's not going to employ you for something they don't usually do, unless you're that plumber. Maybe if you're a tennis pro and you go in to give advice on a play because it happens to be about a tennis pro, like, okay, like they don't really do tennis, right? So I don't know where that idea came from. But, so this is the real kicker, and all 3 factors must be met. Okay. So now we're gonna give you a little pause on the boring law stuff. And we are going to get back into it, but there's been a lot of really wonderful advocacy efforts. A lot of the things you're frustrated about, people already knew people were going to be frustrated about. And the law did come down as it did, but there were some really valiant efforts to kind of try to change it.
So I'm the second VP of the National Writers Union, and we are affiliated with the United Auto Workers. We're nationwide. We represent freelancers in all genres, media and formats, and journalists, book authors, business and tech writers, travel writers, bloggers, work-for-hire writers, again. We do a lot to protect writers, and in 2018 we recovered $200,000 in non-payment grievances for our writers. We're now working on agreements at certain publications to raise rates and set minimum rates, and we also just started a big freelance project, which is just getting off the ground to further those efforts. So we got involved with AB5 after the bill, after the bill was written. We knew it wasn't perfect, and yet we felt that it addressed a major problem in our economy. Across the board, workers were being stripped of protections they should have, while certain employers avoided paying millions of dollars towards their unemployment insurance and other protections by misclassifying them as independent contractors. So, a few examples. We represented 35 freelancers who worked for a textbook publisher that had workers on shifts and supervisors using company laptops. And at the end of the pay period, they submitted invoices instead of, being treated like employees. I was misclassified after being laid off from a publishing company, and at first I could not file unemployment. Then I went to the labor board, and they looked over my pay stubs, they looked at how I worked in the office, they looked at I supervised other employees or other independent contractors, and I ended up being able to draw benefits. And this was in 2008 during the economic crisis, and I would have been like flat on my behind if I had not had this judgment in my factor. So we were looking at it from the standpoint of freelancers, but also our commitment to labor and to lifting labor, everyone who works basically. And while there are many cases where people are misclassified, where Assembly Bill 5 becomes law in January, there are some freelancers who really are independent contractors. They're being harmed by companies who have reduced the amount of business they do with California freelancers.
Yes.
Some have cut them out altogether. And I wanted to express concern and compassion for all those who are struggling with this. And we're in December. This is a very difficult time of year to be at loose ends like this. And to say that, you know, National Writers Union, which has been a part of this discussion in drafting and helping to put input in drafting the bill, is going to keep working towards it. We're also working towards with the New York bill, which is probably going to be introduced at the end of the holiday season. And that one will not have, I think you guys know that there are, I think it was 35 submissions a year. You guys are familiar? Anybody familiar with that? In drafting the bill, it was, you know, I think an issue was that there's a lack of familiarity with freelancers, what we do, how we do it, what we need to do it well. We have a science writer who was a weekly contributor to a publication, and now she can only contribute 35 columns because they cut it off at 35 per year. Other than that, they have to bring you up to employee level. So we are also working, we're based in New York, and we are working towards the New York bill, which will not have a cap on how many submissions you can make. And also, a part of the issue with it being exempt from this AB5 so that you can have, you know, a free-flowing career with your money coming in, right? Is that to be classified as a creative professional, they associate that with having a license. And in New York, the language will be something like, has to have a license unless a license is not required for that particular profession. We did work closely with about 20 some odd organizations to look at and represent our issues, but as you may know, the bill was really trying to get at the gig economy folks like Uber and DoorDash and Lyft, who have people working every day, you know, 40, 50, 60 potentially hours a week, and are not protected, not getting unemployment, not getting family leave. And so it was the way it was described to me, it was almost like you're trying to, you know, you're trying to catch tuna and you get a dolphin in the net. You know, and so we're the dolphin, you know, like nobody's gonna make a dolphin sandwich, you know. So but the issue is that now that there's this effort to protect all these workers, and then it's not understood how we work, you know, it kind of throws the spotlight on the fact that our labor laws are really kind of antiquated. They all are understood to be dealing with an employer and employee, and the way that we have evolved in terms of, you know, sometimes our casual relationship with the people that we, you know, that we get our coins from hasn't caught up with the laws that are on the books. So anyway, say some more stuff and I'll say some more stuff.
That sounds great. Yeah, that is exactly what we're concerned about, right? Is there's like this tension. There's so much where, you know, you want more protections, you want to be employed in some ways, but also the way you run your businesses or run your organizations is not based on that. Mm-hmm. And so there's these big tensions, and we're going to talk about some of the exemptions in the California law. Yeah, and Uber and Lyft is a good segue into the next slide. So some people were really, really excited about the change in this bill, right? So this is an organizer with the Mobile Workers Alliance who was protesting outside Uber. And this is from August, this photo. And the bill was signed, the California Assembly Bill 5 was signed into law by the governor on September 18th. People were pretty excited about it in some circles. Some of the Lyft and Uber drivers also don't want to be classified as employees, however. So there's a lot of tension. And I did want to read to you what the Department of Industrial Relations, which is California's labor commissioner, said. They said, and this is, kind of mirroring exactly what Pamela said, employers oftentimes improperly classify their employees as independent contractors so that they, the employer, do not have to pay payroll taxes, minimum wage, or overtime, comply with other wage and hour laws, so on and so forth. And this is what the bill was really trying to change, right? Is not your lives, not your professional experiences, but those employers that were intentionally doing it to kind of cut a corner when they knew that it shouldn't be that way. For a situation like Pamela's, right, where you were essentially an employee and you deserve those benefits afterwards. Now, not every job you have is going to be like that job. A lot of times you have other jobs that are a lot more project-based. But in that case, you really shouldn't have been misclassified as an independent contractor. So, you might have a lot of different jobs where a lot of different factors come up, right? I mean, hopefully you don't have to have a lot of different jobs, but if you do, there are maybe different times when you classify for different things. Okay, so let's talk about workers. And we're gonna talk about workers, and then we can talk about, then we're gonna have a whole section on the employers or the hiring entities. So if you are a hiring entity, just be patient, we're gonna get to you. Okay, so what's gonna change for workers? Oh, and one thing that I wanna say before we change the slide is, people are pushing back against this right now. People are already trying to change the law. However, January 1st, 2020, it goes into effect. So I'm not saying don't lobby, I'm not saying don't advocate, I really think you should. But I want you to think of this year as maybe a year where you have to change things, maybe just for a year. It's worth thinking about it that way so that you don't get in trouble in this year, even if we're able to change the law for the coming years. So that's the caveat that I want to say. Okay, so what concerns might workers have? These are the things that are going to suck if you become an employee. So the first thing is that traditionally an employer controls your schedule, they control your salary, they control the manner and means, that's a quote from the Borello and Sons case, the manner and means of accomplishing the result desired. So not only do they say, write me that article, they say, and it needs to be 5 paragraphs, and I want to see each paragraph before you turn it in, or before it's completed, right? Then you also do not get to write off business expenses on your taxes. You used to actually, until 2017, don't know who changed that tax law. You used to be able to write off unreimbursed business expenses even if you were an employee. And you said, my employer didn't reimburse me for this, I get to write it off. Now that's not true. So, you basically, if you are an employee, unless you get reimbursed for those things, you can't write them off on your taxes. And then last, and this is a really important one, your employer likely, we talked about the presumption before. The law makes a presumption of one thing or the other, makes a presumption of employee. The law also makes a presumption that your employer controls and owns the rights to the creative works you make. So they own your copyright, they may own your trademark or patent if you do those kinds of things, and that is an automatic thing that now you, as the creator of that, have to overcome. So those are the things that are not ideal. So one note on works made for hire. In the state of California, if you have a contract, it has to be written down. If you have a contract that says you have a work made for hire, under the Labor Code 3351.5, you are already an employee in the state of California. So before AB5, before anything else changed, the work for hire provision in the Labor Code of the state of California said that you were already an employee. So you want to pay attention to that, because if you're like, I pass all the AB5 tests, I totally am in one of those exemptions, or I have my own business, and I still want to be an independent contractor, if your contract written down says work made for hire, the state of California will assume you're an employee. Sometimes it's fine. Sometimes that's helpful for you. Sometimes that means somebody owns your copyright. So you really, really want to be cognizant of that. This is just the information on the Copyright Act. It does talk about what a work made for hire means, and it gives you 2 ways that something could be a work made for hire. It's either prepared by an employee or it's commissioned, and then the written contract about the commission says work made for hire. So those are your 2 things. Okay.
So there are some things that workers can do if they are going to be employed instead of being independent contractors. One thing is to protect your intellectual property rights. So because there's this presumption that if you are an employee as opposed to an independent contractor, that the employer will own your intellectual property rights, which doesn't mean they necessarily do, but they will be presumed to if you were to go to court over these rights. You might want to think about what you can do to react to that presumption. So first, if you have an employment agreement, consider requesting an additional paragraph. This might be called a reservation of rights. There is an example here, a little bit about how the licensor, which would be you, the worker, expressly reserves all rights, etc., etc. This is some information that you can find from a Nolo Press book, which is what this is quoted here, or online. You can find a paragraph that is a reservation of your rights, of your IP. If you don't have an employment agreement, consider drafting your own letter or memorandum of understanding, an MOU. These are usually something in letter format. Dear so-and-so, who's my employer, I would like to reserve my rights to my intellectual property, but I'm happy to license those rights to you for whatever purposes that the employer needs to use the intellectual property for. Say, to the magazine for the run of this magazine for these months in this geographical location, for example. So let's talk a little bit about what positive change might occur if you are a worker that is going from being an independent contractor towards going to be employed. So now most workers will be considered employees with just a few exceptions. So that probably means that you're going to start being considered an employee in most of your job situations. As we've seen, your hiring entity decides to keep hiring you. So if you're an employee, this is actually great news in some cases. You will get wage and hour protection. You will get all the legally mandated benefits. So mandatory benefits in the state of California include workers' comp, SDI, state unemployment, paid sick leave. Federal Family Medical Leave Act law also offers unpaid leave from work for certain family and serious medical reasons. You will also be able to request, in some circumstances, reimbursements from your employer under California Labor Code 2802. Then you'll also be on payroll. This means your employer will withhold your taxes and will pay into Social Security and Medicare, matching your contribution to those certain taxes. In addition, you will get paid consistently. That means have a payday that you can expect that's within, I believe it's 10 days from the last date of the pay period. You also will have the option of joining a union if that is open to you. And you'll have qualified protections under things like the Fair Labor Standards Act, the Americans with Disabilities Act, the Civil Rights Act, and more. And we can talk a little bit more about those when we get into the section on employers. Now, some workers are very, very intent on remaining an independent contractor. This is something that is really up to you, and you need to think a lot about how you can actually succeed in doing this. But there are some exemptions from AB5. These exemptions are in certain specific categories and require various different hurdles that you need to kind of jump over in order to get that exemption. But for example, professional services are exempt. These include, and are enumerated in the law, they include marketing, graphic designers, grant writers, fine artists, freelance writers, and photographers. There's some specific requirements of photographers and freelance writers that we were discussing before, and this includes that there are no more than 35 submissions to one particular outlet per year, which can get very complicated. And all these professional services also have other requirements, like I said. So that means that you maintain a business location, that you have a business license if that's required in the jurisdiction, or permits, that you have the ability to set and negotiate your own rates, that you have the ability to set your own hours, that you have work with other hiring entities or hold yourself out to customers as a business that does that service. And so this is a really specific exemption. A lot of people are like, oh, great, I fall into graphic designer, I'm all set. And that's not really how it works. It's really more about whether you fall into that enumerated category and you match all these other requirements. And one other note that I need to make, which we've kind of talked about, is Borello. Once you pass the AB5 tests, all you do then is fall back into the bucket of Borello, which has 11 squishy categories that a judge might apply to your case if there was some kind of disagreement about whether you're an independent contractor or an employee. And, I do think that in light of this law, judges may be, and any other entity that might do an audit might be looking at those Borello factors more intently. Another way to remain an independent contractor under AB5 is through a business-to-business transaction. Now, this is a great way to remain exempt without being in one of those enumerated categories that we talked about before. However, this has a lot of those hurdles you have to jump over. So you need to be free from control and direction of the contracting business. You need to be providing services directly to the contracting business rather than its customers. So it's complicated, right? The lighting designer designs the lights in a theater production. Are they designing those lights for the theater company or for the audience of the theater company who's watching the production and seeing it with the lighting design? Probably for the company, but there are cases that are a little bit more complicated than that, where you are maybe writing something for the consumer to read. And then are you writing it for the magazine or the newspaper, or are you really writing it for the consumer? So these are things, this especially comes up with like a teaching artist situation. If you're teaching students directly, those seem to be the consumer or the customer of the business that's hiring you, as opposed to you giving that service to the business. You need to really think about that. You also need a lot of other things. You need a contract in writing. You need the required business license that was aforementioned in the other exemption. You need a business location that is separate from the contracting business's location. So that means that could be your apartment, but that means you need to have that business location on record as the address for your business. You have to be engaged independently in this established business. You need to actually contract with other businesses to provide the same or similar services. So that's kind of like what we discussed before in the previous exemption. You basically need to say, I am a sculptor that sculpts for various different places and various different businesses, and I'm just contracting with you, hiring entity, for this one time. As opposed to say, I'm an artist, but I mostly, deal in music, and I'm gonna make this sculpture for you. So then you also need your own tools, vehicles, equipment, and you need to be able to negotiate your own rates and set your own hours. So these are all requirements, and you really need to decide if you meet them in order to fall into this business-to-business exemption from AB5. And again, Borello always is the fallback if you pass the AB5 tests.
I'm exempt. I didn't even do 35 submissions to that place. You have to remember Borello. This is that test that nobody knew existed before now when we're talking about these tests, right? There's 11, now they're squishy factors, but there are 11 factors that you have to kind of land more on one side than the other of all these factors. Or weigh in maybe 8 out of 11 or something like that. It's up to the judge in that circumstance. But the Borello test definitely exists, like I talked about, that floor, even if you pass the AB5 test or are exempt from them. Okay, big changes for hiring entities. I know this is nerve-wracking. I just want to reiterate that thing again. This is for the next year. You really have to think about not having things enforced on you, not having lawsuits for the next year. But maybe in the next Assembly bill and Senate cycle, there will be advocacy that changes this law. Lots of people are concerned about it.
And also, they're introducing it in New Jersey, which is not so different from what we're doing here. But New York, it's perceived that some of the changes that they're making to the New York law that are more favorable to freelancers will be looked at and can be used to upgrade California law.
So pay attention to what other organizations are doing elsewhere in the U.S. because then maybe that's something that you can get, with your union, with your organization. Californians for the Arts, I know, is represented here. Other organizations that represent artists. At California Lawyers for the Arts, we don't lobby, but we, kind of assist artists and maybe crafting some some language that they might want to submit to the lobbying organization. Pay attention to what's happening because you can really maybe make a change. Yeah. Okay, for employers, here's the things you need to change. Suddenly you're going to have a lot of independent contractors for whom it is safer if you employ them. It's safer for you, it's safer for them. Now, many big companies, Uber, Lyft, DoorDash, a lot of these big companies, they're not doing it. They're like, we're staying independent contractors, sue us. They have real deep pocket. So they can say, we're not even gonna try it. We're not gonna change, we're not complying with the law. And they're gonna get sued. They're gonna get sued by their workers, they're gonna get sued by the state of California. And so if you're a business entity that doesn't wanna get sued, unfortunately, you probably can't thumb your nose at it like Uber and Lyft are doing. So, what do you need to do? You might need to pay workers minimum wage. You have to comply with other wage and hour laws, which is the stuff we talked about, overtime, meal and rest breaks. Meal and rest breaks are kind of flexible things. You know, if somebody gets a chance to check their phone and gets a chance to like sit down and have lunch, that's probably okay. You know, but what you want to do is be connecting with your employees and seeing, you know, seeing if they have enough of that relaxation to go get those breaks. You also have to offer the mandatory benefits, right? Workers' comp, state disability, state unemployment, paid sick leave in California, and FMLA, which is the federal law that's family medical leave. And that is unpaid leave is a federal law, but that you can't get fired for taking leave because you or a family member is ill. And then, you know, Fair Labor Standards Act, and then a bunch of other things. And so this is the time when employers, hiring entities, small and large, are gonna have to start really looking at HR, right? Like, there's some things that you're gonna have to start complying with that never have been on your radar before. So we talked about the Americans with Disabilities Act, talked about the Civil Rights Act, which protects from discrimination based on race, color, religion, sex, or national origin. But also FEHA, which is the Fair Employment and Housing Act, that's a California act, that has a really long list of protections. It's the same things in the Civil Rights Act, but it's also ancestry, physical disabilities, mental disabilities, medical conditions, marital status, sex, gender identity, gender expression, age, sexual orientation, and military veteran status. So California really protects its workers, and you really need to think about complying with that. I mean, hopefully everybody's complying, right? Like, no problem, right? But this is why big companies have big HR departments. You know, they fire someone because they're a certain age. They're like, oh, you're 80, you're kind of move a little slow. You can't do that. We can't. You know, and that shouldn't be a factor, right? So then you also have a couple other acts that are new in California that are worth paying attention to. You have the Crown Act, and that ensures protection. This will come into effect in 2020. Ensures, or it actually might have already gone into effect in July, but ensures protection against discrimination based on hairstyles, for ethnic hairstyles, and you don't have to straighten your hair.
It's called the Crown Act?
The Crown Act.
Yeah.
And it stands for something fabulous too. It's like respecting all hairstyles. I love
that.
But yeah, it's fabulous. And people are getting discriminated against. People would say you need to shave off your dreads before you work here, and that is not okay. So California is actually making it law, which is fabulous. And there's other states that are trying to do it too. California also just passed SB 1343, and this is sexual harassment training. This is any employer having 5 or more employees has to provide 2 hours of classroom sexual harassment training to supervisory employees and 1 hour to non-supervisory employees within the first 6 months of them being employed.
Wow.
The state is trying to make this low cost for nonprofits and small businesses. You can look on the Department of Industrial Relations website. They should give you some suggestions. And there's online things you can do that make it cheaper than getting like a whole contractor to come out and do the training. And then there's the California Fair Chance Act. This is also called Ban the Box. And this prohibits employers with 5 or more employees from asking about your conviction history until they make a conditional job offer.
Oh wow.
So it's awesome, and it's really important for a lot of people.
Yeah.
So these are all things that employers have to think about, but also that employees get. So they are kind of complicated to add in, but it also shows that there's a cultural change that's happening that says more people should get more protections like this. Mm-hmm. So it's worth thinking about that. Okay. But what happens at scale? Right? When you're a small entity, when you're a nonprofit, you know, how do you do this for a bunch of different people? How do you do this for a bunch of different independent contractors that you were so used to contracting with that now they're employees? What do you do? And so one thing to think about is some things may come out in the wash, right? Like now you're employing a bunch of people that were independent contractors. This means some people's pay might go up, but maybe some people's pay might go down. And like maybe that's not the ideal thing for the employee, but maybe if you're like, hey, we're giving hourly wages to everybody, we gotta kind of balance it out. And you get all these extra protections, we're withholding taxes for you, we're doing a bunch of stuff for you, so we're giving hourly wages to everybody. Maybe it'll kind of balance some things. Also for your payroll requirements, I did the math, it's probably about 9.25% of whatever you're paying for someone to add them into your payroll. So let's say 10%, let's round up. So you're throwing somebody $1,000 for a contract. To put them on payroll, you just had to add $100. Now that might be a lot if you have 100 employees. It might not be a lot if you have 5. So there are some ways to kind of think about the administrative cost in a way that's not quite as scary. I'm not saying don't try to change the law, but I am saying if you have to deal with it for this 1 year and employ a bunch of people, maybe there's a way that you can kind of try to balance it out for yourself. You also may need to adjust your hiring practices, and that more has to do with the things like the ban the box law and discrimination laws. You just have to be non-discriminatory in the way that you put out your job descriptions and in maybe your ADA accessibility, things like that. Usually you don't have to change your whole facilities, but you have to kind of try to make accommodations for folks. So, everybody's wondering, how do we avoid employing more workers? How do we keep independent contractors? And this is kind of the answer to how do I stay an independent contractor, right? The exemptions we talked about, graphic designers, grant writers, fine artists, and more. But remember, still have to pass the Borello test. Also these business-to-business transactions. Maybe you try to find more people that have an LLC and do their own advertising, and that's really more what you're looking for if you're trying to do just project-based work with folks. If they can have a small business, it could be just a sole proprietorship. And as long as they pass those other tests that the exemptions require, maybe you don't have to put them on payroll. They still do all their own taxes. Another option that might work for a lot of organizations is hiring through a staffing agency or doing what's called a PEO. So professional employer organization, they do your human resources, right? They do your paying their wages, they do the taxes for you. And what ends up happening is you have what's called a co-employment relationship. So that means the hiring agency, the staffing agency, they're the employer for tax purposes. So they do all the taxes, they sort all that stuff out, they make sure all the discrimination laws and all those other laws, family medical leave, etc., are complied with. And you get the control of the hired worker. So that's a thought too. There's a link in there that talks about it from the National Professional Employment Organization, the organization that works nationally with PEOs. And they said that it is, actually this is a CNN report, but they say it's usually between 5 and 15% to use a staffing agency of that person's pay. So does it, now you're kind of thinking like maybe it's a balance, right? Put somebody on payroll, it's maybe about 10% of the cost. Do a staffing agency, maybe low, maybe a little higher, but also maybe saves you a headache. So it's really, all of these things are really personal. They're really individual to each business.
But if you work for that staffing agency, do you get any of the protections?
Mm-hmm. You do, because you will be employed by that staffing agency.
Okay.
Mm-hmm. Mm-hmm. So you won't be an independent contractor. If you are the worker, you'll become an employee of the staffing agency, but you might still get hired by the places you're used to being hired as an independent contractor for, because now you're with the staffing agency, and that small organization doesn't have the headache. So arts nonprofits around California have talked about maybe like doing some kind of co-op, doing some kind of like pooled HR resources. I don't know if some unions are kind of thinking about that, but there are places that try to do that for employers and employees to connect them, and not in the traditional like staffing agency sense where you just go like as a temp. And there can be like work style specific agencies, right? The actual sector of employment that you're in, it can be specific to that.
We have a freelance project, I cannot remember, it's FSP, we have a freelance project that we are exploring basically the nature of the relationship between the freelancer and the entity that they're working with. And we also started a legal fund recently too, because we are constantly having to represent people who are not getting paid, so that's a big issue in these times.
Yeah, and you're gonna have to do a lot of preparation. It's really kind of complicated. There's so much that can be done with things like this, right? With getting together and saying, we need a legal fund, or getting together and saying, there's some freelancers like unions that help you cover healthcare. Maybe there would be a similar thing to help you get employed in places that would usually only hire independent contractors. Mm-hmm. Yeah. Remember, Borello, this is just to try to remind you, even if you pass some of those tests in AB5, there's gonna be other tests, and people are gonna be looking at these more now. So what happens if I don't do anything? What if I take the Uber and Lyft route? So, wage and hour laws are generally enforced by the California Labor Commissioner, also called the Division of Labor Standards Enforcement, or the DLSE. They're also under the umbrella of the Department of Industrial Relations. So any of those three things, Labor Commissioner, DLSE, Department of Industrial Relations, all kind of the same entity for our purposes. Employee classification may also be reviewed by EDD, which is the Employment Development Department of California, by the Federal Department of Labor, or by your workers' comp carrier. So if you employ some people who get workers' comp, and then your workers' comp realizes that you have a bunch of independent contractors that shouldn't be, they're gonna be breathing down your neck. Because you know what? They want a higher premium from you. And so they have a real incentive to try to get you to have more employees. The California government will generally not unilaterally initiate a case against the employer. More often this happens because, like Pamela, you're a worker that said, I should have gotten benefits for this. This was not how I was not classified properly. And so when a worker initiates a claim, that is really when a business is gonna have problems. And often one worker initiating a claim can lead to a bunch of investigations of that organization or even of that whole sector. So sometimes it happens, you'll hear about like restaurant like raids, right? Like so one restaurant is not giving everybody meal breaks, say. And then all of a sudden like the labor commissioner is coming in and saying, you know, to all these different restaurants, like you need to pay better or you need to give breaks. One other thing, somebody files a complaint against you, retaliation is a huge issue. Do not retaliate, do not fire them. You will get in so much more trouble because it's a whole separate cause of action that they can bring against you for that retaliation. So, best thing to do, try to fix it. Usually, in terms of the labor commissioner, if somebody files a complaint, you'd usually do have some kind of mediation process at the labor commissioner stage. So hopefully you can work it out with them. Penalties for violation, they're scary. You know, you gotta pay back wages, you gotta pay unpaid overtime, unpaid minimum wage. But then there's also, you know, if you didn't pay somebody for sick leave, that can be a lot of money. But even if that's not a lot of money, you're also gonna pay penalties, you're gonna pay interest. So they only had 10 hours of overtime that you were supposed to pay them back 6 months ago. Well, you might have a bunch of interest you owe them now. You might have penalties that could be another half of that money. So this can come up to thousands of dollars. You also may have to pay their attorney's fees if they win. And then additionally, there's some extra penalties. So if you are willfully or repeatedly misclassifying people, it can be between $5,000 and $25,000 penalty. So this is why you don't want to mess up for this year. It's going to cost you some money to employ people. It will cost you a lot more money if you get in trouble for not employing people. So let's think of like some more positive things. Strategies for employers. Treat your workers well. Talk to them. You know, try to establish your worker classification with certainty. If it's on the edge, if you're confused, employ them. Put them on payroll. You know, maybe do it by an hourly amount and just do kind of a shorter project than you thought you might need and then go for it. You know, when people think about payroll, they think, oh gosh, they have to be on payroll for the next year. You can put them on payroll this month. And then if it's working out and the project's working out, then maybe, you know, you pay them next month. You just have to be giving them the protections that that are required. So then also remember that independent contractors that you employ should only be those exempt from AB5. Don't choose a random independent contractor that's doing something that doesn't seem to be exempt and just like hope. That's probably not a good look. And then workers, advocate for yourself. You know, you're used to negotiating your contract as an independent contractor. Someone says, you know, you gotta be an employee now, say, okay, but I want this hourly rate. See how it goes. You know, it's like a tag sale. So say a high amount, say a low amount, then maybe try to meet in the middle, right? If you don't fall into an AB5 exemption and you know you don't, you really gotta start confirming with everybody who hires you that they're gonna put you on payroll. Technically, it would be you, the worker, that files a complaint, right? That causes a problem. But you also don't want to not be complying with the law because it can get you in a lot of trouble. And as the worker, you probably won't get in trouble. It's more the hiring entity that'll get in trouble. But now that you know the law, it's worth advocating for yourself because then you also get all those great protections, right? You break your foot, you're gonna get workers' comp, right? And then also, if you feel you're being misclassified, and this is something that's really important with having hiring entities and workers in the room, maybe don't go right to filing a wage claim. Maybe the first thing you do is you talk to your employer or you talk to your hiring entity who just hired you as an independent contractor and you sit down and you say, I actually think I was owed this. Can we work something out? It's always worth worth asking, right? If you don't ask, the answer is always no, right? And also remember, retaliation is unlawful. So if they were to fire you, which happens, then you also have that other claim. You have that additional question. So just a couple more things. Employers. So this is when we're thinking about at scale. Maybe you need to consider getting an HR consultant. If you're a nonprofit, maybe there's somebody on your board who either knows something about HR or has information about an HR consultant that you can get. If you can't pay for a consultant, try to find some kind of situation where somebody would be willing to volunteer. Consider joining a professional employer organization or a hiring agency. Another thing that nonprofits are doing in California is leaning on their funders, leaning on their grants and saying, hey, it's gonna cost me 10% more to start employing people properly. I need that 10% more in this grant, or I can't use it. Can't even use my grant money unless I have this extra 10%. I'm not saying anybody's saying yes yet, but there have been funders on the table. There have been funding agencies, and grant making organizations that have come to the table and said like, hey, we're getting together extra pots of money for this. We know it's going to be a big change. If you have earned income, right? Maybe you need to, and you're an organization, maybe you need to increase things by 10%, right? So a ticket to your show's $25 or $50. Maybe it's, $27.50 or $55.
You do math.
Right, you gotta do math. If you hold dance classes, maybe your class is gonna be $21.50 now instead of $20. But maybe that extra $1.50 from every person can pay that worker at an employee rate. Contractors, now is the time that if you want to be a business, get your LLC. Start thinking about what it is to be a business. Because you do a lot of this stuff for yourself anyway. You're already hustling, right? You're already doing so much work for yourself. You're already putting yourself out there. You're already advertising on your social media. You already have a business address because it's your apartment. So maybe you start really trying to make yourself a complete entity that could do those business to business transactions. And also, if you qualify for one of those exemptions, like you are a graphic designer or you are a freelance writer, you also want to make sure that you qualify for all the other parts of that exemption. So start looking at that law now. Start trying to figure out, is there a license I was supposed to get that I didn't get? Probably not, but maybe, So those kinds of things where you can actually start prepping for this in a way that isn't scary, that is just like little bit by little bit, starting to comply with the law. And like I said, maybe it's only 2020. Maybe we only do this for a year. Maybe everything only shifts like crazy for a year and then we get some more exemptions in the next round.